The People's Amendment Bill 2001. Shri Arun Jaitley ji.
Madam, I beg to move that the representation of People's Amendment Bill 2001 be taken up for consideration and approval by this Honourable House. The thrust of this bill, Madam, relates to two special aspects with regard to the procedure for elections to the members of the Council of States, that's the Rajya Sabha. We've, since 1951, had a firm system where to be eligible under Section 3 of the Representation of People's Act, to contest for the election for the Rajya Sabha, one has to be an elector of that state. And under Section 19 of the Act, in order to be an elector of the state, you have to be a person ordinarily resident in that state. Now, several features over the functioning of this election system have come to notice. For one, in a large number of cases, political parties which send up representatives from various states have sent up persons who traditionally were not residents in the state, but for the purposes of election to the Rajya Sabha, got enrolled as electors in that particular state. If we do recollect, about 6-7 years ago, there was a large controversy whether this practice now requires to be changed as far as the legal system is concerned. We tried to develop a consensus amongst political parties. Some of the political parties took a particular view that a change perhaps is now required. Some people still had reservations about this. And one of the points of criticism which was made against this proposal was that this may perhaps affect the spirit of federalism, which is otherwise inherent in the fact that it's only an elector of a state who gets elected from that particular state. Under the existing system or the proposed system, it is the members of the Legislative Assembly of the state who are the electors. It is their option whom they choose to elect, who they feel can best represent the interest of the states. As against this, several arguments have been given, which I present before the Honourable House, as to why this system requires now to be altered. One of the first reasons why it requires to be altered is because in the matter of its actual implementation, a breach too frequently was witnessed. And therefore, political parties wanted to come to an honest assessment of the situation and come to a conclusion where this perhaps now requires to be altered itself. The second, that under our constitutional scheme, under Article 19(1)(e), a person has a right to reside anywhere in the country. So a person who wants to change his residence, there may be cases where people maintain more than one residence. For reasons of business, for other reasons of family, people may be residing in more than one place simultaneously. And therefore, this perhaps may not be in a position to deal with such situations, the existing situation. The third reason, which was also, besides the factor of multiple residences, that there may be some states where even the ruling party or a ruling combination may be unrepresented completely as far as the Lok Sabha is concerned, may be unable to bring members to the upper house who are amongst the usual residents of that state. Therefore, in order to make sure in the government also there is representation of those states, there may be a compelling necessity to get some ordinary resident of that state elected from some other state. It has happened in the past. It has happened even today that there is one particular state which was completely unrepresented otherwise as far as the NDA is concerned, both in the Lok Sabha and the Rajya Sabha. And therefore, members were got elected from other parts of the country in order to make sure that those states also get a representation in the Council of Ministers. Now, with these facts, the government had introduced this bill. There were two views even before the Standing Committee. The second component of this bill is with regard to the methodology of casting their vote amongst the legislative assemblies as far as the election to the Council of States is concerned. Currently, we have a system where parties put up candidates, but we've had several cases, I've got a list of cases, where in the last few years, we certainly have seen some kind of unusual practices, not very happy for our democracy, which have crept into the polling system. Cross-votings have taken place for reasons which are not entirely political, as a result of which it happened in Maharashtra, it's happened in other states also, where candidates put up by political parties have lost. And in fact, on an earlier occasion, I do recollect when we were discussing the bill for proxy voting for the armed forces, some of the honorable members of this House Mr. Lalu Yadav and others did mention that there is a great necessity that this procedure itself be changed immediately. And therefore, after consulting a large number of political parties who agreed to this, the second proposal is to bring about a change in the methodology of voting, and the voting as far as Rajya Sabha election is concerned be by an open ballot.
Correct.
Now, the procedure for this open ballot, I may very straight here at the very outset, that the procedure for this open ballot is not prescribed in the primary legislation, but would be prescribed as far as the rules are concerned. And the government, in accordance for those procedures, would welcome suggestions from all members of this House today in the course of debate. We would also, after the act is passed, we would welcome suggestions from political parties subsequently as to what that exact procedure could be. We'll also consult the Election Commission. One procedure which has been suggested is with regard to at least the recognized political parties all having polling agents, and those who have been elected as members of the Legislative Assembly on the symbol of that political party would be compelled to show their ballot to the polling agent itself. And the rest would be then a matter of the party's own discipline. Some members have even made suggestions whether 10th schedule itself could be extended. But since 10th schedule is a matter which deals with the legislative business, and casting their vote outside it strictly may not, there may not be a need to apply it at this stage, and therefore the consensus being built up was that it's not necessary to apply it at this stage. For the present, the methodology of voting be converted from a secret ballot into an open ballot. The procedure, I can assure this House, we'll certainly discuss with the political parties, take their suggestions, take the views of the Election Commission, and only then formulate the procedure. I have given one illustration. This is not a firm view of the government, but this is one possibility. If there are other suggestions, we would welcome those suggestions. One point of criticism which had been made against this procedure itself has been that secrecy of ballot itself is an essential component of every election. This is a point some people have made. And therefore, conversion of a secret ballot into an open ballot may perhaps defeat that purpose of secrecy. Madam, I wish to correct this impression. Elections must be fair. In fact, in relation to the Rajya Sabha elections itself, the Supreme Court in 1980 had an occasion to deal with a situation where a vote was shown to somebody else, and the question raised was that the secrecy has been destroyed and therefore the election itself gets nullified. I'll just read out a paragraph of what the Supreme Court said. This is the case, I don't think the member is present here, of Mr. Raghbir Singh Gill versus Sardar Gurcharan Singh Tora. Secrecy of ballot was mooted to ensure free and fair elections. If the very secrecy of ballot, instead of assuring free and fair elections, strikes at the root of principle of free and fair elections, this basic postulate of democracy would be utilized for undoing free and fair elections, which is the life and blood of parliamentary democracy. If secrecy of ballot, instead of ensuring free and fair elections, is used, as is done in this case, to defeat the very purpose of election, purpose for which it is enacted, to suppress the wrong coming to light and to protect a fraud on the election process, or even to defend a crime, that is forgery of ballot paper, this principle of secrecy will have to yield to a larger principle of free and fair elections. Therefore, if secrecy is leading to a situation where corrupt practices have overwhelmingly crept into the system, the question for this House, therefore, in this question would be, will this principle of secrecy then have to yield to openness, which may perhaps provide some sunlight, expose those who indulge in these practices, and then leave it to the parties to decide what action they want to take against them. Openness, therefore, by a large number of members has been felt. The matter went to the standing committee. It was chaired by the Honorable Shri Pranab Mukherjee. There were two views on the standing committee, and the committee, therefore, could not come to a firm recommendation as far as this bill is concerned. After considering the recommendations and the various views expressed by the standing committee, the government was of the firm view that it is now time both to change the residence requirement, which was a condition precedent, as also the methodology of voting as far as the Rajya Sabha election is concerned, in order to ensure that the election system becomes much cleaner. With these words, Madam, I commend to this House that this bill be accepted.
Thank you. Shri Pranab Mukherjee.